So yeah, this is about law. That's right. So while this topic might seem, like it could be boring for people, I don't think it is. I think it's very important for us in Web3 to kind of talk about this stuff. Dan Artev here, he's going to moderate. The others are panelists. And Dan's going to go through a few different topics that have to do with law and blockchain, including like the SEC lawsuits and different things. We'll leave that part to him. But then we'll kind of just going to get the opinions from the different other speakers and go around for the next hour. And like I say, we're all dealing with blockchain. We're doing crypto transactions and stuff. A lot of us might not think about law or like taxes and whatnot. Granted, we're not going to be talking about taxes here much, but these are all things that are changing all the time. Especially here in the U.S., it seems like the SEC doesn't know what they want. So this is the topic that we're going to cover, and it does affect our future. And we hope that things work out in the best way possible for us in the future. But it's good to know, be at least knowledgeable about what's going on. So with that, let me give it over to Dan Artev. He's actually my attorney. That's how we know him. And we have an AMA interview with him tomorrow to go more about his firm and what he does and examples of what he's done for me and stuff. But right now, we're going to focus on this panel.
Thanks, Breakman. Yeah, I'm Dan Artev. I am the founder and managing partner of Artev at Law. It's a law firm based in Michigan. We focus on gaming law. That's how we started out in 2020. And as Breakman said, I am the attorney for Consumer Breaks. That's one of my gaming clients. If you haven't checked out that game, I'm going to give them a plug. That is a really cool skill-based game that everybody needs to play.
Thank you.
So, yeah. So anyway, we're going to try to make this fun. We're going to try to make this exciting. As the previous panelist said, NFTs are all a scam and super illegal. That means there's a lot of work here for the attorneys, but I'm just kidding about that part. But yeah, it's a really interesting space. It's something that's full of innovation and constant change. And I personally find that really interesting when there's not hundreds of years of established precedent, and common legal questions can be interpreted many different ways, and there's a need for legal opinions. And it's just something that's always been really interesting to me in any area of law. And I found this specialization in gaming law that kind of blended really well with NFTs, with play to earn, with blockchain explosion that took place over the past couple of years. So that's kind of where I'm coming from. We got 3 panelists here with us. I see Mark. Is anybody else here?
Well, we got Washington, and then we also have Gary Adelman. He is on the way.
Okay. Wagonston is here, and he can speak. His avatar is still not here up front. I guess if you want to stay in the back, he can.
So we got, Andrew.
He's trying to get up from the seat right now. The seat glued him to the chair.
There's a button at the bottom for sit up. That's not working. It's right there. Get up, it says.
Well, that's all right.
Yeah.
What I was going to do is just start out by introducing the panelists really briefly. And then I was just, I'd like each of them to give us,
Yeah, we love that too. That'd be great.
About themselves. I'll introduce Mark Cianci first. He's an attorney out of the Northeast and from a firm called Ropes and Gray. And what I know about Ropes and Gray is it's a big law firm. And Mark represents a number of clients in various industries. It appears that his focus is more on the transactional side of things, and crypto is one of his expertise areas. And Mark told me that he actually recently wrote an article about the SEC versus Ripple Labs, the XRP decision that we'll be talking about in a little bit here. So Mark, welcome. If you want to give the panel a little bit more of your background, please.
Yeah, thank you. And can everyone hear me?
Yep, we hear you great.
Yeah, we got it.
Great. Perfect. It's great to be with everyone. And yeah, that's a really nice introduction, Dan. Appreciate that. The one adjustment I would make is I actually do a lot more work on the litigation side, and some of that bleeds into transactional and compliance and regulatory. But I'm a litigator by training and by background, have been in practice for 12, 13 years. Yeah, 13 years at this point, and have a history of high stakes litigation on behalf of clients in various industries, including life sciences, private equity, and various investment strategies. And then over the past 3 years, I've done a lot of work in the digital asset space that includes digital asset litigation, as well as strategic counseling for digital asset developers, issuers, owners, investors, and users to ensure that in this new and emerging and still somewhat ambiguous and unclear environment, operators and everyone else are doing what they can to stay compliant and avoid litigation risk, be that private litigation or government litigation. So that's my overview, and I look forward to getting into details with everybody.
Thanks, Mark. I apologize for labeling you as a transactional guy. I'm personally biased against litigation because I did commercial litigation for 10 years. Then I started my own law firm, and I'm like, I'm not doing this anymore. So that's why. So with that said, Andrew Wagner, he's here somewhere, I believe.
He's right next to you now, Wagenstein.
Where's he? Oh, there he is. He's okay.
Right behind you.
Yeah, no, on my screen, Brakeman is blocking him.
Oh, so there you go.
All right.
Can you hear me?
Yeah, we got you.
We can.
Yep.
Yay.
Hey, Andrew. Andrew's the founder of blockchain gaming, among his other functions. He's a guy that's involved in a lot of interesting stuff. Blockchain gaming, I cannot believe I have not heard of this website before. Reviewing your profile as part of this, I will definitely be checking this out as a gaming attorney that's also involved in a number of crypto issues. That seems like a gold mine for information and topics for me. So with that, I'll just turn it over to Andrew for further introduction. Go ahead.
Oh, yeah, okay. You guys can hear me all right?
Yeah, we hear you great.
I'm on my phone. Okay, good. Yeah, sorry I'm late. Yeah, like you said, I'm mostly focused on blockchain gaming, but in the past, I've also done a lot of nonprofit stuff in the crypto sector, and also in some other industries like English as a second language. And I've had some, from a regulatory and legal standpoint, had some interesting perspectives. For example, I've been a contractor for the Nigerian government, where they summon some central bankers and lawmakers, and I'm supposed to try to teach them how crypto works. And it's a thing that happens once a year. And lawmakers, at least in Nigeria, are still not completely knowledgeable of how crypto works, to be frank. And I've been watching what's happening in the US, and obviously I have biases, but I disagree with some of what the SEC is doing and saying.
I don't think you're the only person in the room, Andrew. And I would, as a U.S. attorney, I really don't think that the Nigerian lawmakers are the only ones who are clueless. And in my personal opinion, we could definitely all benefit for some more clarity from Congress, among other places. So is Gary here? Gary Edelman? Is he on his way?
Yeah, he's on his way. I'm trying to get him to call me.
Okay. No
So
problem.
if he pops in, yeah, we'll let him start. But yeah, go ahead with the first topic.
Well, yeah, Gary's supposed to be our intellectual property copyright resident expert, because I know there were a couple of questions for us before that. But in any way, welcome everyone again. Thank you so much for being here. I'd like to invite both Mark and Andrew to just quickly go over maybe a couple of examples of applications that they've seen where blockchain's particularly useful or used a lot in this industry. What kind of industries are you seeing using blockchain technologies, Mark?
Yeah, happy to take a first stab at that. Look, I've seen it in virtually unlimited forms of application. So thinking about, for example, what we do on a day-to-day level, there are so many products and services that we interact with, whether that's agricultural products, manufacturing products, services that are sourced from a variety of geographies, where there's an uncertainty, and the law around this is evolving really rapidly to ensure that in the process of receiving products, receiving services, users in the US, but also virtually all the other developed nations are not supporting directly or indirectly human slavery, human trafficking, human abuses, but developing workable, reliable constraints and structures around those supply chains has been one of the most challenging aspects to ensure compliance with those regimes. Now enter blockchain, where you're able to associate in a very seamless, low impact way a particular identity with all kinds of things. And you can imagine an NFT associated with a shirt that comes from another geography, or with a cup of rice that comes from another geography. That NFT is virtually costless to create and virtually costless. Hey, I broke up there, but what I was saying was that those NFTs are virtually costless to create and to maintain. And by integrating those NFTs with ordinary course supply chains, people are already starting to be able to develop greater compliance with anti-slavery and anti-trafficking regimes. And ultimately, the goal there is not just compliance, but promoting human flourishing, promoting human success. So that's a real tangible way where this emerging technology is getting overlaid into existing streams of commerce in very powerful ways to promote the good.
Thanks, Mark. That sounds like there's a lot of application there, and that's only one additional reason why we could definitely benefit from some more regulatory clarity from Congress. Andrew, I know blockchain gaming, obviously, is the name of your website. Have you encountered application of blockchain in any other industries, and what kind of things are you seeing in gaming? I mean, play to earn obviously comes to mind. That's what I'm most familiar with. But what about you?
I mean, it's pretty widespread. I would agree that generally blockchain is applicable to a lot of industries, or any where trust is an issue or where centralization is an issue. I've also worked in the ESL industry and attempted some implementations there. But blockchain gaming is kind of a first mover. It has advantages in that, when I do something with English education, or if you wanted to do something with real estate or something like that, you require the cooperation of officials and authorities to integrate with the existing system. When I build a game, I don't have that problem, right? As the developer, I can say blockchain is respected in this version. And that makes it a low-hanging fruit, I think, in an industry that's primed for taking advantage of it before others do. In gaming, it's all about play to earn is one thing. A lot of people are now about play and earn. The idea that blockchain runs in the background, but it's still like a regular game. Some of those games, because of game development life cycles these days, take years and cost millions of dollars. Those games are still in development, but are expected to be released. There's trailers and stuff you can look at. Well, there's also NFTs, in-game items, right? They have utility. And finally, I'm most excited about fully decentralized games. The idea that we can play a game without a server. Zaya does this, for example, and it's truly fascinating, and I could talk about that forever, I guess. Maybe there are legal implications, I don't know. The best example I give people is Hunter Coin, which was the first fully decentralized MMO. And the best way to explain what it's like to have an MMO with no mods or admins is to, if you've seen South Park, they have an episode about World of Warcraft where maybe someone's laughing because they've seen it, I don't know, but a character in the World of Warcraft in South Park gets too powerful and begins to slay the mods and admins and take over the World of Warcraft. And so the boys have to band together and defeat him by the rules of the game, by leveling up their characters. And in fact, this scenario occurred in Hunter Coin. We called him the Dominator. That was his nickname. And he was pseudonymous. And he also utilized AI. We don't have a decentralized Turing test. So there's no way to prevent botting yet in this environment. And so he took over the world of Hunter Coin. But in the show, the boys defeated him, but in reality, we lost. We banded together, and the Dominator defeated all of us. And so we forked the blockchain, and to undo his malicious behavior. And that's the interesting kind of stuff that can happen in blockchain gaming.
That's an amazing story, Andrew. And I was laughing because in this age of streaming, I own one episode of South Park, and that is the episode of South Park that I own. Actually paid money.
It's a great
for.
one.
And I'm a big former World of Warcraft player, and I definitely got some of those vibes walking around here a little bit.
Nice.
But in any case, yeah, I appreciate that. That's really interesting. It made me want to check out Hunter Coin until you got to the story about the fact that it doesn't work, but maybe the part works.
Hunter Coin's back from like 2014, and so it's very nascent technology. The new they've made a thing called Zaya, but they still don't have a decentralized Turing test, and I think we would still have difficulty defeating the Dominator until it's accomplished. But it's interesting, right? Because the game world runs on its own.
Yeah.
If you were to go to the developer's office and burn it down, or if meteors struck it, the game would continue to function. How would regulators deal with that if they chose to dislike the developers? Or they could arrest the developers, but the game doesn't need them to operate. It's completely blockchain based.
That is one of the very interesting issues that is not even only inherent to the gaming field, but blockchain in general. What if these people are minting NFTs and operating coins from everywhere, and it doesn't matter what the regulators think. But that's actually a nice segue. I wanted to give a little bit of time here to talk about this recent decision that blew up on social media in the Bitcoin, or not Bitcoin, the cryptocurrency and the blockchain discussion boards. This decision in the case of the Securities Exchange Commission versus Ripple Labs, it was back from, I believe, 2020 that the SEC first filed this lawsuit against Ripple Labs that launched the XRP token, basically accusing Ripple Labs of a number of securities laws violation. And it's kind of a case that us lawyers that are in the space have been watching pretty closely, because it would give a lot of indication about what the SEC's thought process was on this, the developing field of cryptocurrency regulation. It would also give us a good idea of what the courts are thinking about this. And so recently there was a big decision in the case. The New York Southern District of New York federal court granted partial summary disposition, resolving some of the issues in the case, while not resolving all of them, but certainly giving a lot for the lawyers in this particular industry, in this particular field, to talk about. So I'd like to get the panelists' thoughts on this. I personally, my my reaction was that it's not as simple as a lot of people on Twitter and other social media sites made it seem. So I think it's a pretty complex decision, and we'll have to see where this goes from here. So, Mark, I know this is right up your alley, so I'd like you to start, please.
You bet. Well, look, I think you touched on it pretty accurately, Dan, when you said there's a lot of complexity here. I think it might be worthwhile just to take maybe 30, 60 seconds and talk about some of the main holdings from the decision, because that itself has gotten a little muddled in the process of everyone talking about what went down. Look, there are three main holdings coming out of the decision, but there's a common thread that unites the three holdings, which is Judge Torres out of the Southern District. What's that?
Oh, Gary's here.
Oh, I'm here. I made it. All right.
Hi, Gary.
Hey, welcome, Gary.
I'm so sorry. Like I couldn't get in here.
All right. Well, we're all here now.
All right.
We're all here now, and Mark's talking about his thoughts on the SEC versus Ripple case and the recent decision. So we'll let him continue, and then you can share your thoughts as well.
That'd be great. Thank you very much.
Awesome. Go ahead, Mark. Sorry about that.
No, not at all. I'm glad my buddy Gary is here. So the key overarching unifying principle that animated all three core holdings of the Ripple decision is that, at least for Judge Torres out of the Southern District of New York, the evaluation of whether a digital asset constitutes a security cannot be addressed in a one-size-fits-all manner. So, for example, the SEC coming into the Ripple case was saying XRP either is or is not a security. And of course, they were saying it is, but they were looking at it in a very binary way. Judge Torres said, no, you can't just decide at a global macro level whether the XRP token, that digital asset, is itself a security for all purposes. That digital token is really something more in the nature of a commodity. So what you really have to look at is the transactions in which the token was transferred. And based on the facts and circumstances of those transactions, you can evaluate whether such transactions constituted security sales. So that's the overarching theme. And then the three subholdings are, in the case of the sales of XRP to certain institutional investors that had contracts and reviewed all kinds of investment materials in exchange for their and paid considerable value pursuant to those contracts and investment materials in exchange for their XRP. Those transactions were found to constitute securities transactions. Conversely, however, two additional categories: A, where XRP was just being sold via exchanges, and B, where XRP was being given in exchange for services. Neither of those categories of transactions, according to the judge, involved the sale of securities. And so it's something for everyone on the SEC side and on the defense side. But overall, I would say it's much more defense and industry friendly because of point one, that the judge decided not to look at XRP as a monolith, but decided to instead look at the facts and circumstances. And point two, the vast majority of transactions in XRP, as in with most other fungible tokens, occur across exchanges of one form or another. So, well, the decision doesn't necessarily say all transactions on exchanges in digital assets are non-securities transactions. It has a lot of tidbits and a lot of principles that can be leveraged to get to that outcome. I'll pause there.
Thanks, Mark. That's very insightful. And if anybody's interested in learning more about this from Mark's perspective, he co-authored, I think, a very, very good article that I believe it's on your website, right, Mark, on the Ropes Gray website?
That's right. Yeah.
Okay. Yeah. So I think everybody who's interested in that should check it out. I found it very useful. Gary, welcome, by the way.
Thank you.
And I wanted to give you a chance to, first of all, introduce yourself and maybe give a little bit of thoughts on this issue, if anything else to add to what Mark said.
Sure. Happy to do that. My name's Gary Edelman. I'm the managing partner of a business and IP protection firm called Edelman Matz in New York, LA areas. We primarily focus in the entertainment, tech, and content space, and we do all the traditional law, commercial, corporate, trademark, and branding, litigation. Unfortunately, you're a recovering litigator, I hear, and
That's right.
And employment law. And we've in the last year, well, actually, in the last 2 years ago, I helped co-found a tech conference in the Hamptons called Hamptons Tech Week, in which Mark was on my panel the last 2 years. We're very excited about continuing that. But so my comments on Ripple are fairly simple. And while I agree with, what Mark said about the decision, I actually disagree with the judge's decision. I think her initial decision, which is that it's not a monolith, is true, and that it should be fact based. And she did find that the sale of the tokens were securities initially. The other two sections of the decision, I think, are wrong. I think that what XRP was doing was clearly a security under the laws they had set it out, and I know that's going to disappoint a lot of people. But the fact of the matter is that what she said in the second prong was just because it was basically, she called it an anonymous exchange, an automatic anonymous exchange. But the fact is that most exchanges are not actually anonymous. You know who you're exchanging with. At least the username and password of the person you're exchanging with. But nevertheless, I still think it's a security, primarily because of the third prong, which is the expectation that you're going to be making profits. And the thing that's interesting to me about the whole case is why people would be cheering that XRP is not a security. Like, why wouldn't you want to have regulation in this area? That is the question I've been asking everybody. Why would you want to let a company like XRP just get up there, make up tokens, and then sell them and profit without it being regulated at all? That's my big question for you and the audience, actually. And I know I'm on the opposing view of everybody in this audience. I'm sure everybody else wants it not to be a security, but I don't know how it can be that way. That's my opinion.
Thanks for sharing that, Gary. And I think that's a really good point. And it highlights, we have two attorneys here, Mark and Gary, with different views. And I'm sorry if I'm putting words in your mouth, Mark, but is your take that the decision was correct, or you had some problems with it as well?
I agree with the notion that you can't take a one-size-fits-all approach to a digital token. A digital token in its own right is much more in the nature of a commodity. And so I agree with that. I also agree with the decision. And so I'm going in a different direction from Gary here. I also agree with the decision insofar as if there's no linkage between the purchaser of a digital asset, in this case, diffuse individuals across exchanges on the one hand, and the initial issuer of the digital token, in this case XRP, on the other, it makes little practical sense to infuse such transactions with the regulatory overlay of securities. And I think there are numerous structures and regulatory regimes that exist irrespective of whether a digital token is characterized as a security. So, for example, you can't lie, cheat, or steal in transacting with another person or another business, irrespective of what that thing is. That's just baseline law. So I think it's an overstatement to say if it's not and I'm not saying this is what Gary's saying, but I'm saying for other people out in the community that are saying, oh, unless it's a security, then it's going to be unregulated. I think that's an oversimplification, because there are other bodies of law, consumer protection law, fraudulent business practices laws, and certain laws promulgated by the CFTC that prevent fraudulent conduct in connection with commodities, that provide a layer of protection, irrespective of whether a digital token is conceived to be a security.
I mean, you know what's interesting is that you're trying to differentiate commodity from security, when the judge actually says in the decision that commodities are securities and can be securities. And orange juice, gold, etc., are sold on the commodities exchange, but they're regulated by the SEC and by the they're considered securities. That's what she said. So I'm wondering how you slice and dice that.
Well, guys, I'm going to jump in here just in the interests of time, and I apologize, but this illustrates a very good point that I was about to make, that we are going to see this appealed all the way to the Second Circuit Court of Appeals, and we might have more clarity or might have a completely different decision. I do a lot of gaming law, so I love this example. There's a 120-page decision out of the Southern District of New York on why Texas Hold'em poker is a game of skill and is not regulated gambling. It was widely celebrated. The Second Circuit Court of Appeals took that, threw it out. Texas Hold'em poker is gambling as far as New York state law is concerned. So we will see. I wanted to actually let Andrew jump in here. And Andrew, what's your legal background? Do you have any legal training, any of that stuff, or just kind of as a developer?
I'm more in the project building side of things. I can say why people don't want things to be classified as securities, and there are two primary reasons. One is laziness. So it takes time to be KYC'd, and to do KYC, even I succumb to laziness, to be honest. I'm actually not particularly big on my privacy all the time. I mean, I'm showing my face right now. I don't really care I don't commit crimes and I have nothing to hide. But it's annoying when, like, I'm on my laptop downstairs and my wallet's upstairs, but there's some KYC demands and I gotta get off the couch. And there are some platforms that don't demand that. And I'm willing to bet that the unwillingness to go take selfies is what's driving a huge number of people away from KYC platforms. It's annoying. It's also, I would say, it can be difficult. I think when you classify it as a security, it has the net effect of supporting finance industry incumbents, because there's a cost to implement a lot of what the regulators are asking. And a lot of the developers I work with are from poor backgrounds who frankly, they just have no chance of meeting those costs. It's not possible. I mean, unless they, go before Wall Street or get some new backers of a large size, but it's just prohibitively expensive for a lot of them. And so they view these regulatory pushes as existential threats to their careers and livelihoods, a lot of people. And I think it would be easier if we could figure out ways to make regulations faster and cheaper to comply with and to apply to people. Because I don't really think people trying to avoid the law is actually one of the biggest reasons. I mean, some people are doing that, but it's not why a lot of people are doing that. And in terms of the SEC, I don't like what they're doing generally. I don't know if you're just trying to focus on Ripple now, or you're going to dive more into what they're doing with Coinbase and other companies. Is that then a next question?
Yeah, I think we should talk about that briefly. I wanted to ask Breakman, are we? How much time do we want to leave for questions?
Oh, it doesn't matter too much. Just go. We're going to the hour. Towards the end, 5 minutes left. We can pull questions or something. But I think this is better just to go with your speaker. We're just kind of learning along the way here. If anybody does have questions, just throw them into the chat, and we can try to pull them up later.
Yeah, that sounds good. Okay, yeah, I wanted to get everybody's perspective because again, I see a lot of kind of generalization out there on social media about after the XRP, the Ripple Labs decision came down, people are saying, oh, well, then the SEC has to stop litigating against Coinbase, has to stop litigating against Binance. I'm sure you guys, Mark and Gary and Andrew, you're all aware that there's this ongoing litigation against some of the big exchanges. And I wanted to get you guys' take on how this Ripple decision has impacted these ongoing lawsuits, if it has impacted them at all. And I'd actually asked Gary if is Gary still here?
Gary is trying to come back in, so start with somebody else, please.
Well, since you're still here, Mark, you can start and give us your thoughts.
You bet. I think that it's important to keep in mind that this is just one decision by one court. And it actually comes on the heels of a number of decisions by other federal judges that are equally empowered, equally prominent in terms of their position within the judiciary that came out the other way. So, for example, in 2022, the district court for the District of Connecticut, a federal judge, concluded that a number of digital assets and digital tokens were securities. You have the decision out of the District of New Hampshire earlier this year concluding that the library tokens were securities. And those judges elected to not endorse, I mean, it hadn't come out yet, but they didn't endorse the reasoning that undergirded Judge Torres's decision in the Ripple case. So I think it would be an overreaction to assume that other judges are going to align their thinking with the Ripple decision as opposed to other earlier decisions that came out the other way. Now, the counterpoint there is the Southern District of New York, even though it's just another district, is viewed by many jurists and many lawyers as being a thought leader. And so maybe judges in other districts, including, I mean, one of the Coinbase and Binance cases is actually in the Southern District of New York before a different judge. So there may be some momentum and some pull of Judge Torres's decision with other districts, but it's by no means to be assumed that you should just translate Judge Torres's decision in Ripple into the Coinbase and Binance cases. That said, I think that there is a lot of, and you've heard this in my prior comments, there's a lot of intellectual firepower and intellectual force around Judge Torres's decision, and certainly going on right now, not only by the SEC, but also by private parties under similar theories. Certainly, defense counsel in those cases are going to try to leverage the Ripple decision. And of course, to the extent that it is appealed, the Ripple decision, on an interlocutory basis, which means before a final judgment and the Second Circuit affirms, then you'll have a Second Circuit court within the U.S. judiciary system endorsing the reasoning of Judge Torres, and so it will be much harder for district courts, and certainly impossible for district courts in the Second Circuit, but also much harder for district courts beyond the Second Circuit to avoid it. So the SEC has to think really, really hard about whether it wants to appeal this decision, because they could inadvertently actually strengthen law that goes against their positioning.
Thanks for that, Mark. And with that, I would like to pose the question, any chance of our esteemed Supreme Court granting cert in a case like SEC versus Ripple?
Who should take that?
No, to you, Mark.
All right. Look, the way that the federal courts are organized, you have the district courts, then sit on top of that are a number of federal circuits, and then those are the intermediate appellate courts, and then the Supreme Court sits at the very top of the federal level. The Supreme Court will never accept a case for cert unless there is, at first, what is called a circuit split. So one circuit court, we've been talking so far about the Second Circuit, comes out one way, and then another circuit court comes out a different way. At that point, and that distinction has to be really clear and really direct. And at that point, the Supreme Court will entertain cert. It doesn't necessarily have to grant cert, because it could find, oh yeah, well, it's not a real concrete dispute, or the dispute hasn't ripened because only 2 circuit courts have come out and we want to wait for 9 or 10 to come out. So the short answer is not for a long time. The longer answer is eventually, once there's been a sufficient bubbling up of opposing views within the various circuit courts in the United States, which we haven't even had a decision like this go to any of the circuit courts yet. So it'll take quite some time before the Supreme Court weighs in.
Yeah, that's very true, and that's a very good point, Mark. So we're a ways away from that. Andrew, I wanted to give you a chance to chime in and give us your thoughts on this, the ongoing litigation against the exchanges.
Yeah, I guess my legal expertise is not as extensive as some other speakers, but I do have opinions, obviously, kind of familiar to a lot.
Please.
Of crypto people in general. I've been following the Coinbase stuff, because some of us were surprised that Coinbase was targeted, I guess, because in the crypto community, like diehard fanatics, Coinbase had been perceived as like part of the man and like prone to regulations, and was viewed as stuffy. And now, our views have changed. A lot of people are cheering for Coinbase. Ripple's funny, because Bitcoin people used to hate Ripple. Like, Ripple was the boogeyman. Everyone would be mean and say bad things about it in the Bitcoin community. But now all of a sudden we're cheering for Ripple, which is something I never would have guessed years ago. It was kind of interesting.
For sure.
There are some comments, like particularly one comment that irked me was at a panel at which Coinbase and an SEC officer both attended. It was Gerber Gruel. Yes, I remembered what he said, because it was annoying. And it betrayed, like some of them seem to have emotional views of this subject, and I think have some kind of vendetta. Like, I'm pulling up the quote here, but basically he said he was offended. Let me see if I can find his exact words, but he says they're promoting crypto with the promise of financial inclusion to a segment of the population that has been excluded from traditional finance. That's offensive to me. Why is that offensive to you, sir? I mean, maybe he thinks that they're being taken advantage of, but I find that a rather paternalistic view, in that, I've done, so one of my past nonprofit things, CoinVest, free to attend conference. Super popular in the developing world, particularly Africa. And in some of my games, like particularly in Hive, it's mostly Spanish speakers, people from developing countries. And what I've noticed is that actually Binance is more popular in developing countries than it is in developed countries. And largely this is due to they lack as good of financial systems and infrastructure in their countries compared to what I have available in Canada. Canadians don't need Binance. But people in Nigeria do, frankly put. Like, the central bank guy was recently sacked. One of them, like, I saw him at conferences, and he's gone now due to corruption and appointing his son to positions that he wasn't qualified for. And that's just what they deal with. And so if you ask them, who do you trust more? This shady Chinese guy operating Binance or your own regulators? Frankly, they trust Binance with their money more than they trust their regulators. And it's kind of insulting to their intelligence sometimes. Like, basically, there's some viewpoint that these folks aren't educated enough to know how to protect themselves or know what's in their own best interest. And I think that if they had been present at the conference, they probably would have booed or thrown tomatoes if available. They would have been annoyed. And yeah, I guess that's my thoughts on the matter. I had a bone to pick with Mr. Gruel.
I think that is a great comment, and I fully share your sentiment that it's paternalistic and very kind of, I guess, first world problem type of thing. Look at these guys, Binance. We have a great financial system where you should be giving your money to the hedge funds, to the Morgan Stanleys, and it kind of reminds me that I always. Whenever I'm watching TV and I see one of those like commercials for an investment firm, it's like always an older couple doing what they wanted to do 30 years ago, but finally they have the money to do it. And the point's always, oh, give us your money now so you can do fun stuff later. And I think that's absolutely ridiculous. And it kind of goes into what you were saying. It's just like, we know better. And who are you guys to do what you want with your money? So I think that's a really, really interesting perspective, especially, Andrew, when you mentioned, developing countries, and that it's not the U.S. way or system all across the world. So
yeah, and I would say,
yeah, go ahead.
Oh, just I guess my last comment is like, Mr. Gruel's had time, right? The finance sector has been around for decades. So I guess just instead of being offended, he should build more banks in Nigeria or invest in a company that does.
Right.
But now I'm ranting. Sorry.
No, I appreciate that. Is Gary back or no? I just want to make sure I don't leave him out.
I don't think he is.
Oh, right. No problem. Mark, I wanted to get your thoughts on something that I get a lot of questions about, and maybe you get a lot of questions about, and that is just from a very basic corporate law perspective. People who want to start a company, they always want to know what's the best state to incorporate in, or where should they form their LLC, or should they form a corporation? In your experience with anything blockchain related, is there a particular corporate structure that you think works best, or you think is most advantageous to people in this industry? What are your thoughts?
I'm going to go a little bit off the beaten path here, because I think there's a lot of conventional wisdom in the blockchain space that says incorporate or put your form of organization, whether it's a corporation or not, in a state that has a specific statute or an updated statute designed to account for blockchain type structures, and or in a state that is especially friendly to blockchain. So states that get thrown around a lot include Wyoming and Tennessee and Vermont. I actually, working with a lot of newer companies that are starting up and trying to get a lot of funding, trying to infiltrate the VC world, I actually find that kind of so someone just said Wyoming is trash, no cap. I think that's a more direct way of getting at what I'm getting at, which is I think a lot of VCs and a lot of people who would otherwise want to align with some of the newer companies get thrown off when entities are organized in unfamiliar jurisdictions. They have their playbook in terms of who they want to invest in. And so, and that playbook typically includes a Delaware C Corp. VCs are very used to investing in Delaware C Corps. So when new blockchain startups come and are trying to raise capital with something other than a blockchain, other than a Delaware C Corp, it can raise alarm bells, raise eyebrows, and potentially be an impediment to capital raising. Now, if a situation where someone is just self-funding or doesn't need outside capital, especially from VCs, then that consideration obviously evaporates. But for many who don't want to rule out getting VC funding either at an initial raise or at a secondary or third raise, I would as a default matter tend towards a Delaware C Corp for that financing reason.
That's very, very true. And I would also ask you this, Mark. What are your thoughts? Have you ever had anybody come to you and say, I want a DAO under Wyoming LLC statute?
Yes, I have.
And what was your reaction?
I said, why? Well, we need to come at this from a more macro perspective. So I put together a table that looked at a variety of DAOs across, and in this case, it was a charitable DAO. So they had more of a public good purpose. And I said, okay, well, thank you for that suggestion. And they were not a lawyer. They were in business. And I said, let's do a survey of main structures, typical structures and typical geographies and jurisdictions that DAOs are incorporated in, and map on specific functions, features, and purposes for those DAOs against what you are trying to put in place, and come up with a cohesive recommendation. I think there's a lot of lore around blockchain law. Somebody hears something from somebody who ultimately heard it from a lawyer, and they just latch on to that. Whereas I think good advice requires coming at it from a more customized, bespoke perspective. So in that case, I gave them the table and we worked through the ultimate selection, which did not result in selecting Wyoming law, but not for any particular reason.
Yeah, and I think that's a great point, because I think a lot of people, at least that I've talked to, just assume that a Wyoming DAO is the only way they can incorporate. And as Mark pointed out, well, you should consider, a Delaware C Corp if you're going to be raising funds, because that's what venture capitalists are looking for. So I think that's a very, very good thing to keep in mind. With that, I wanted to actually open it up to questions, because we have 5 minutes left. If there's any questions.
Yeah, and you can throw them in the chat or come on The Voice. On this last topic with incorporating, I mean, does that mean that there's tons and tons of companies that are all Delaware C Corps, huh? What about just making a company in the state that you're at, an LLC? I know that the laws would be different in each state. I'm in West Virginia. I have a West Virginia LLC, and things are fine right now. But I guess to your point of the VCs, they would be looking for Delaware C Corp. But let's pretend that's not the case. Would an LLC in your state be just fine to do a blockchain company?
I think the answer is yes. But Mark, what are your thoughts? Because I think LLCs are simple. And if you're, unless you're seeking, you know, venture capital
for a startup
investment.
too, I'm talking about like an independent trying to create a project, not some big company that started or anything.
I think it can work. Mark, what
I agree. And before I got fully integrated into providing litigation services and advisory services to blockchain companies, I started a mining business, and I started it with some others, and we did not pick a Delaware C Corp for our entity because we weren't looking to raise outside capital. We picked a jurisdiction where one of the other founders had a residence, and we made that, and we picked a LLC in that state. So I think there's a perfectly appropriate reason, especially if you don't want to have to go and create a separate corporate office in some state where you have no presence. You just want to use your residence. This is for ultra early stage startups. Yeah, pick an LLC in the state that you live and have your residence, your personal residence, be the address of that entity. And then you can always, if things scale or you want to start a new entity that has more external funding, there are some tax considerations around reorganizing, but that's something that's manageable. And look, I should have said this at the outset. All of this is not my legal advice. This is just my overall perspective, having been in the space for a while. And you should consult an actual engaged lawyer who's your personal attorney for any decisions that you're going to be making in this realm.
Cool. Thank you very much. That was great. Yeah.
So Breakman, we're not moving you to Delaware.
not yet. What is the reason that VCs are only going there? What's the benefit? Why Delaware?
Standardized paperwork.
Okay.
And Mark's going to say predictable courts.
Yeah, I mean, Delaware is the leader amongst, and maybe this is embedded in what you're saying, maybe it's not, but Delaware is the leader amongst all states for all business organization. It's where, if you look at the Fortune 500 or Fortune 1000 companies, I bet you 99.9% of them are incorporated or organized in Delaware. And so there's symmetry between the massive companies at their late stage and some of the early companies when they're still getting accumulation of financing. Delaware has the market leader in corporate law. Yeah.
But you wouldn't, like all these companies doing that, they don't actually have a corporate office, right? I guess they'd have a shell. Is that what they call it? A shell office?
They can designate, oftentimes they have whichever law firm incorporates for them, they can have a nominee. There are certain Delaware organizations where for a small fee, you can assign that organization to be your agent for service of process and whatnot. And so there's a very simplified way to set up shop in Delaware.
Yeah. So it's like your headquarters there, but your actual headquarters where you do your work and all is wherever it is. They're not all moving to Delaware. Yeah. So.
No. And that's a very common distinction. Most companies have a place of incorporation and a place of headquarters, and those are most often not the same.
Yeah. So that's the distinction. Okay. Great. Any other questions for the guys up here? I know. Maybe it was kind of above some people's heads, but it was interesting, right? This is all stuff that's happening, and we do got to think about it, even if we're not really interested in it. It does affect us. Right now, like they said, there's still time. There's going to be more court sessions. It's going to move. So as things happen, we just got to keep up with it. But yeah, hey, NFTOPIA is a good place to keep up with things. So come on back.
Absolutely. And as Breakman mentioned, I have a booth here. I think it's a Nouveau Hall.
Mm-hmm.
Yeah, Nouveau Hall. So come on and check it out if you're looking to, find my Twitter page.
Yeah, and if anybody
interact me there
has a project and you're considering a legal opinion or anything, or even just a consultation, you're not completely sure about how the legal affects what you want to do, you can definitely holler especially at Dan. I'm sure also the other guys. Dan will do a free consultation, and if you want to go further and have an opinion, he'll quote that and do it. He works really well with you. I've done numerous opinions for Consumer Break, so just
yep,
a heads up.
Yep, I'm based in Michigan. Mark, you were in Boston, I think. Gary's in New York.
Yeah, we're from all over the world. Everybody here,
all over the place,
and we don't have to meet in person. That's how we're doing it right now. All you need is a phone and some email, and you can make it all work. So.
Yeah, so thanks for that, Breakman. Mark, thanks so much. Andrew, thank you so much for your time. I really enjoyed talking to all of you and getting to hear your various perspectives. I thank Gary too, but I don't think he's here. So thank you all.
Thank you all.
Thanks, everyone. Bye.
Thank you all for coming.
Bye.
Showing your expertise. That was great. That was great.
Yeah,
Thank you.
thanks so much, guys.